On May 1st, 2021, a 53-year-old man named James was sitting quietly on a bench outside a closed bar while waiting for an Uber at 2:27 a.m. in Wheat Ridge, Colorado, when an officer from the Wheat Ridge Police Department parked his vehicle and approached Mr. James.
How you doing?
Good.
What's going on?
Waiting on my Uber.
Waiting for your Uber?
Yeah.
You have an ID I can take a look at, man?
No, you don't. I don't. I'm not doing anything wrong.
Well, you're sitting in front of a closed bar and I can see you're
waiting on my
intoxicated.
Uber, my friend.
Let me see your ID.
No.
Okay. We can do this one in two ways, sir.
We can do this many ways.
I'm being respectful to you.
I'm sitting here waiting on my Uber. I am doing nothing
Show me on
wrong.
your phone that your Uber's coming.
You know what? I want to break out my camera right now.
Go ahead, mine's running
I want
as
to
well.
start filming you.
Mine's running as well.
I am not doing anything wrong.
Okay, well.
I'm doing everything right. Not drinking and driving. And why are you messing with me?
I'm not messing with you, sir. You're sitting in front of a closed bar. You're sitting in front of a closed bar.
You are messing with a Navy veteran that is waiting on an Uber.
Sir, I'm going to ask you one more time.
That is doing nothing wrong.
Can I see your ID?
No, you can't.
You're drunk in public.
No, I'm not drunk in public.
Give me your ID.
The officer demands that Mr. James show his ID, and Mr. James refuses. Section 16-3-103 of the Colorado Revised Statute states that, quote, "A peace officer may stop any person who he reasonably suspects is committing, has committed, or is about to commit a crime, and may require him to give his name and address, identification if available, and an explanation of his actions." The Colorado Supreme Court held that, quote, "In determining whether an officer had a reasonable, articulable suspicion, this court focuses upon whether there were specific and articulable facts known to the officer, which taken together with reasonable inferences from these facts, created a reasonable suspicion of criminal activity to justify the intrusion into the defendant's personal security." The court also noted that, quote, "When determining whether reasonable articulable suspicion exists, the relevant inquiry is not whether particular conduct is innocent or guilty, but the degree of suspicion that attaches to particular types of non-criminal act." In a statement issued by the Wheat Ridge Police Department after the incident, the department claimed that the officer was justified in demanding Mr. James's identification because he was outside of a closed bar that was the scene of a homicide by stabbing in August 2020 at 2:27 a.m. However, courts have consistently held that an individual's mere presence at a location without more does not rise to the level of reasonable suspicion required to justify a Terry stop. While many states have public intoxication laws, in the state of Colorado, there are no laws prohibiting being drunk in public, which means that the officer also could not detain Mr. James on suspicion of intoxication. In fact, Section 27-81-117 of the Colorado Revised Statutes explicitly prevents political subdivisions from passing local laws that institute criminal or civil penalties against people that are intoxicated in public. Under these circumstances, it seems likely that a court would find the officer did not have the reasonable suspicion necessary to demand Mr. James's ID lawfully. The officer places Mr. James in handcuffs. In general, police officers do not have the authority to demand to see information or data on your cell phone without a warrant. In the 2014 case of Riley versus California, the Supreme Court thoroughly addressed privacy rights and cell phones, holding that it was unconstitutional for police officers to search the data on a cell phone that was lawfully seized during an arrest without first obtaining a warrant.
I was sitting in the chair, not bothering anybody.
Sir, I was trying to be reasonable with you.
Oh my God, dude, I am a Navy veteran.
Okay, thank you for your service.
And I'm just sitting there minding my own business.
Right, at a closed business.
And waiting on my Uber.
Sir, and all I asked was for you to verify it. All I asked you to do was show me it on your phone, and I'm good with that. Okay, but you refused to do that, so you couldn't do that.
You guys are, I mean, really, you're going to do this to a Navy veteran?
Sir,
I'm sitting on a
have a seat in the car.
My Uber's
Is there anybody sober that can come get you?
You're not listening.
You're not, sir.
I called an Uber.
Well, you can't call.
The Uber was 2 minutes away.
You can't.
You shook me down.
James, we've been here for 10 minutes and they're not here. You can't call Uber. Okay? That's not the way.
Phone?
That's not the way Uber works. He's got your phone.
My phone.
He's got your phone right there.
Look it up. Whether I call an Uber or not.
You can't call them on the phone.
Did you do it through an app or did you
I
call
did
them?
through the Uber app.
All right, so how do I get into your phone?
6969.
If they're coming, man, I'll release you to them. But if not,
6969.
but if they're not, you're not
And
leaving
then
us much
look out
choice.
for Uber.
The officer informs Mr. James that he will release him to his Uber driver if one was on the way, but also suggests that he would arrest Mr. James if an Uber was not en route. While the department's official statement about the incident cited this law and claimed that the officer would have been authorized to take Mr. James into protective custody because he, quote, showed signs of intoxication and inability to care for himself, the standard that the statute requires is that an individual be clearly dangerous to themselves or others. And the only signs of intoxication Mr. James showed were slurred speech and slight cognitive impairment. Colorado law does not specifically define what it means to be quote-unquote clearly dangerous in this context, but Section 27-65-102 of the Colorado Revised Statutes defines the term danger to self or others, which is the standard used for emergency mental health detentions. The definition states that an individual constitutes a danger to themselves when, quote, the individual poses a substantial risk of physical harm to himself or herself as manifested by evidence of recent threats of or attempts at suicide or serious bodily harm to himself or herself, and is considered a danger to others when, quote, the individual poses a substantial risk of physical harm to another person or persons as manifested by evidence of recent homicidal or other violent behavior by the person in question, or by evidence that others are placed in reasonable fear of violent behavior and serious physical harm to them as evidenced by a recent overt act, attempt, or threat to do serious physical harm by the person in question. Because individuals cannot be taken into protective custody simply for being intoxicated, and Mr. James did not appear to pose a danger to himself or others, a court would likely determine that Mr. James could not have been legally taken into protective custody in this situation.
Listen, fellas.
There's a green button.
I am a former combat medic.
James, thank you for
Sitting
your
there,
service.
How do you,
and I'm not going to lie to you.
how do I go?
6969.
He's in
I'm
it.
in.
Uber.
Where do I search that? I don't have this
Go
stuff.
to the Uber app.
Mr. James eventually gave the officers permission to look at his phone and verify that an Uber was on the way to pick him up. Mr. James was then uncuffed, and the officers waited with him until the Uber arrived. Mr. James thanked the officers and shook their hands before departing in his Uber. It is unclear whether Mr. James filed a complaint or took any follow-up legal action. Overall, the Wheat Ridge officer gets an F for baselessly accusing Mr. James of several irrelevant crimes, detaining Mr. James with no reasonable basis for doing so, and for displaying a fundamental misunderstanding of the Fourth Amendment. Mr. James went out of his way to ensure that he got home in a manner that was safe and compliant with the law, and it is difficult to understand why the Wheat Ridge officer went to such great lengths to verify Mr. James's story. The officer could have achieved the very same results of this encounter by simply standing by and observing Mr. James until his Uber arrived, but instead, he chose to force Mr. James to surrender digital data that the officer had absolutely no right to. The officer also accused Mr. James of being drunk in public while on private property, and attempted to criminalize nearly every element of this encounter as he escalated it into an unlawful detention. This encounter offered the Wheat Ridge officer a prime opportunity to exercise his community caretaking function by standing by with Mr. James until his Uber arrived. But the officer turned what could have been a chance to build a positive relationship with a member of the public into a full-scale detention. As for Mr. James, it is difficult to assign an accurate grade to an individual who was under the influence of alcohol during the interaction. As you all have likely experienced, remaining silent is never high on the priority list for individuals under the influence of alcohol, and it is common knowledge that decision-making skills can be affected while intoxicated. I commend Mr. James for remaining calm and collected throughout the encounter and for challenging the officer's commands.